My name is Lauren. I'll be your host for today's presentation, where we're going to hear from one of the industry's thought leaders on OFAC and recent changes to Cuba regulations. We're excited to have over 700 people registered from all over the world for today's webinars. It's clearly a hot topic and we're excited to get going. Today's presentation is brought to you by Global Radar. Global Radar is the premier client onboarding, know your customer, and transaction surveillance software used by leading financial institutions all over the world. And we're very pleased today to have Andres Fernandez as our guest speaker. Andy is a partner in Holland & Knight's Miami office, and he's leader of the firm's Cuba Action Team. He practices in the area of banking, law, and financial services with a focus on licensing, regulatory, and compliance matters. With an emphasis on issues pertaining to the Bank Secrecy Act, anti-money laundering, and Office of Foreign Assets Control, Mr. Fernandez counsels a broad range of clients such as domestic community banks, foreign banks, broker-dealers, and money service businesses. A couple of housekeeping notes before we get started. Please note that all audience members are on mute due to the large number of participants. However, throughout the presentation, please feel free to submit your questions using the chat feature located on the right-hand side of your screen. We'll address as many of these questions as we can at the end of the presentation during our Q&A portion. Also, the slides are available for download under the handout section of the same panel on the right-hand side of your screen, so please feel free to access those. And with that, I will turn it over to Andy. So, Andy.
Thank you, Lauren. Thank you, Dominic, Global Radar, for inviting me to participate and be the speaker at today's webinar. It's great to be here. As Lauren mentioned, my name is Andy Fernandez. I'm a partner with the law firm of Holland & Knight. I am a member of the firm's financial services group, as well as leader of the firm's Cuba Action Team. Before diving in today's presentation, I'd like to just take a few moments to set the stage, provide a backdrop for today's discussion. As we all know, OFAC compliance has been and will continue to be one of the most, if not the most, significant challenge facing banks and financial institutions. And you don't have to take my word for it. Just ask, the federal regulators, the state regulators, and in unison they will agree that one of the top risks facing financial institutions today is OFAC and sanctions compliance. But it's important to understand that it's not just a problem for the big bank, money center banks, multinational banks. It's all of our problems. In today's world of technology and globalization, where you can do most things via your smartphone, via an ATM, you don't really need to go to the branches anymore. Even the small market, domestic, community institutions and firms have a greater exposure to OFAC and OFAC compliance. But it's also safe to say if you are an institution that has a global footprint, or you have foreign customers, NRAs, foreign entities, you have foreign transactions, foreign affiliates, foreign offices, and certain types of products and services, you have a high or a higher OFAC risk profile at your institution. Having said all that, we still ask ourselves, why OFAC? Why should I be spending the next, hour of my day talking about OFAC or listening to OFAC and talking about OFAC compliance? And that's where we get to today's presentation. And I've split the presentation with the time that we have into a few areas. First I'm going to spend some time talking to you about the why, practical reasons as to why OFAC and OFAC compliance is so important. Then I'm going to talk to you about how some of this stuff applies, how some of these sanctions and regulations apply. I'm going to spend a little bit of time talking to you about some common mistakes that I've seen practicing in this area, working with, many different types of clients, big and small, foreign and domestic. Then, I'm going to talk about some lessons learned, some takeaways, and I'm going to spend a few minutes talking about, well, let's say you do run into a problem with OFAC or with a transaction or with a customer. Well, what will OFAC consider when there's a potential violation? And then finally, I'm going to give an update on Cuba. There's been a lot of discussions on Cuba over the past 18 months, and I'm going to highlight what some of the changes have been. So with that, I turn to the presentation, and I'm going to be moving the slides. And starting again with the discussion that we just said, why OFAC? Well, a financial institution needs to focus on OFAC for multiple reasons. First of all, we need to understand that OFAC itself, it administers and enforces economic and trade sanctions based on U.S. foreign policy and national security goals. So OFAC is this notion of national security and security of our financial system, which, folks, we're talking about a very high-level policy that OFAC is enforcing. We're not talking about, you know, a community regulation or a state law. We're talking about very high-level policy that OFAC is enforcing. Against who or whom do these regulations apply? Well, these are sanctions that are applicable against targeted foreign countries, nationals, terrorists, narcotics traffickers, those engaged in weapons of mass destruction. And as we're going to talk about in the next slide or in a couple slides, you know, OFAC takes two basic forms. You have the list, which I'm sure many of you all are aware of, the list that has hundreds of thousands of persons and entities that you are prohibited from doing any type of business directly or indirectly. But also you have countries where there's sanctions against countries and nationals of those countries. And again, we'll talk in a little bit about, you know, what are the challenges with both of those. Who must comply with OFAC? OFAC applies to all U.S. persons and to any transaction that touches the U.S. financial institution. Within the definition of U.S. person are financial institutions. So I always tell my clients that OFAC is a lot bigger than you may think, where it applies to all U.S. persons, not just financial institutions. Also, OFAC applies this concept, this legal concept of strict liability. And what that means is that if a transaction crosses your institution or a customer that is subject to OFAC sanctions crosses or is a customer of your institution and you miss it, it is a violation of law, period. Your best efforts, your best systems, your lack of knowledge, intent, etc., that is irrelevant. Whether a violation of law occurred, it's set. The violation has occurred. Now, we can argue all those things as mitigating factors, but one of the challenges with OFAC is this concept of strict liability. If the activity crosses through your institution and you missed it, it's a violation of law, period. Also, something that I turn to as to why OFAC compliance has risen in the past 10 years so much is, and I point to the FFIEC BSA AML examination manual. As you all know, this manual has become the roadmap that the examiners use or refer to when they're at your institution examining you for compliance. Many people refer to this as the encyclopedia. I've even had people say it's the Bible. But what has happened is that this document, being the roadmap for the examiner, all of a sudden they get to page 146, and there's a significant chapter on OFAC and OFAC compliance. So what we've seen in the last 11 years since the release of the first version of the FFIEC BSA AML examination manual is now many more questions, many more inquiries, many more criticisms, unfortunately, by the examiners during their routine examinations of your institution. We've also seen in 2006 an MOU, a Memorandum of Understanding, that was signed by the federal regulators and OFAC. And that Memorandum of Understanding has led to open discussions, open communications, and information sharing between OFAC and the regulators. What happened before is that the regulators left it to OFAC to enforce their own laws and their own regulations. But now, based on this MOU, if your examiner finds a situation at your firm, at your institution, at your bank, that you're having problems with OFAC, well, guess what? They pick up the phone and they call OFAC, and they let them know. And vice versa. If, and this has happened to me many times, that I'm working with OFAC on a matter where the institution, the firm, has disclosed something to OFAC, and we'll talk about these voluntary self-disclosures towards the end of the presentation. OFAC will respond to us, and guess what? They copy the institution's regulator on the communication. So there's open communication between OFAC and the regulators. And finally, why must we focus on OFAC is, as an industry, we've become a lot more sophisticated. And we'll talk about this later. And because of this sophisticated, we investigate a lot more, we ask a lot more, we get a lot more documents, and as a result, we discover things a lot more than we used to. We detect things a lot more than we used to. And unfortunately, what I've seen has happened is that we oftentimes detect things after the fact that could have been subject to OPAC sanctions. And we'll talk later about kind of some best practices of what we can do, to mitigate, challenges in that area. Moving to the next slide. Now, continuing with why, folks, OFAC is not easy. OFAC is a significant challenge. OFAC, as I mentioned, falls to OFAC compliance, very generally speaking, and when I give talks on this, I try and simplify it. And I look, OFAC falls into two categories. As I mentioned, you have this list-based sanction, that you have hundreds of thousands of persons and entities on this list that you can't do business with. A lot of people say, oh, that's the easy part, because in today's day and age, we have sophisticated software. That software automatically scrubs our database, scrubs our transactions, updates the list, again, kind of does it all for us. But we're going to talk a little bit about how really that also could present some challenges and problems I have seen in this area, because as we all know, technology is awesome, technology is great, so long as it works. How often are you on your phone and a call drops? You're working with your email, your Outlook, and it freezes. You're trying to send a document, it doesn't go through. Yeah, again, technology is great, but it's great so long as it's working, and that's why we've had, this movement towards, again, systems testing and systems validation. The second part of OFAC compliance is this country-based sanctions, where OFAC has issued sanctions against countries, like what we're going to talk about later: Cuba, Iran, Sudan, Syria, Crimea. Again, in my opinion, these are really more difficult because each country's sanction program is different. The sanctions against Cuba are not the same as the sanctions against Iran. And the sanctions against Iran are not the same as the sanctions against Sudan, et cetera. So again, as an institution, you need to have somewhat of, an expertise as to what each sanctions program allows, what it doesn't allow. A lot of times these country sanctions are changing. OFAC issues general licenses. You need to stay abreast. So in my opinion, I always view the country sanctions programs as a little bit more difficult. And then finally, we have this, I call it a juxtaposition between BSA AML compliance on one hand and OFAC compliance. As we all know, BSA AML compliance is about identifying risk and then mitigating that risk, having policies, procedures, and controls to mitigate that risk. Well, OFAC is the exact opposite. OFAC is identify the risk and eliminate the risk because of this notion of strict liability. So these are somewhat, I don't want to say competing forces, but it puts institutions that are mid-sized institutions, smaller institutions, when you often have the same department, the same people, maybe even the same person doing your BSA AML compliance, which is about mitigating risk, and that same person, doing your OPAC compliance, which is eliminating risk. Another reason why we're here, I could sum it up in one word: enforcement. I have friends that are lawyers in other jurisdictions, and I always say this, Andy, they say, hey, I have just as many laws, requirements, reports, et cetera, but what we don't have is enforcement. And here in the U.S., whether it's OFAC, whether it's BSA, whether it's AML, we have plenty of enforcement, maybe even over-enforcement. And OFAC, if you look at the fines, they've been significant over the years, and there's no reason to think that, 2016 and the years to come are going to be any different. Another reason, and I apologize, the slides move somewhat a little bit slow. Another reason why it's important, and this is one that we've seen present a challenge, it's referred to as the 50% rule. Many of you may not even know about this. Many of you may know about this. I refer to it as the secret list that entails OFAC compliance. In 2008 and later in 2014, OFAC issued guidance that states that if an individual that has been designated by OFAC, this individual appears on the OFAC list, if he or she, or in combination with other people that are designated, in the aggregate, own over 50% of a non-designated entity, those people, in fact, contaminate that entity and convert that entity into a specially designated, entity subject to OFAC sanctions. The problem here is that OFAC doesn't publish that list. That list is up to us to identify, up to us to discover. In my dealings with even the biggest money center banks, the banks that have hundreds of folks in this department, have millions of dollars in a budget here, they've told me, Andy, this is the hardest part, because we'll be well aware that this series of individuals are on the OFAC list, but we don't know what interest in entities or what interest in companies they have. So this is a challenge, and I think what you have to do in this area is you have to take care of your side of the river, your side of the fence. You need to have controls in place where if you do have a customer that appears on the list, you need to immediately understand whether within your own institution that customer has an interest in any companies that are also customers of it. You may have to do some open source searches to see if there's any publicly available data to find out whether they have any interest in companies, projects, etc. I know it's hard, it's a challenge, and that's why I put it here towards the front of the presentation, because this is really one of the tough parts of OFAC compliance. We've been dealing with it, representing clients in the past few months with some of the designations that occurred in Honduras in October of 2015, where the Rosenthal family, a prominent family in Honduras, the whole family basically was designated, but then they had interest in property and in entities, all throughout the country that continued to operate. And again, because of this interest, they also contaminated those entities. So again, this is an area that's a challenge. All right, let's move on to how some of this stuff applies. And I'm going to talk again, obviously with the time we have. I'm going to just highlight what are some of the minimums. What are the minimum things you need to be doing to make sure you're complying with not only the letter of the law, but the spirit of the law. And the first thing, as we know in our experience with BSA AML, is we need to identify and in this case eliminate our OFAC risk. And how can we do that preliminarily or at the onset? Is we need to conduct an OFAC risk assessment. We all know that we have to do our BSA AML risk assessment, but you also need to be doing an OFAC risk assessment. You can incorporate it into your overall BSA AML one, or you can do a standalone. That's up to you to decide. But you need to do, the basics. You need to identify what are your high-risk accounts and what are your high-risk transactions, because therein lies the risk, obviously. Analyze your transaction types. Are you an institution that is very, domestic, retail, low cash type of institution, or your institution that you have a significant amount of foreign wires, letters of credit, foreign lending, foreign funds transfers? Obviously, if you fall in the latter, your OFAC risk is higher. What is your customer segment? Again, goes along with what I just said. Are you a domestic bank or you're an international bank? Obviously, if you're a domestic bank, your OFAC risk is likely going to be a little bit lower. If you're an international bank, it's going to be higher. What are your internal controls? How sophisticated is your software? How sophisticated are your policies and procedures? Have you had a history of OFAC blocking, OFAC reporting? And at the end of the day, you need to determine what is your OFAC risk rating, so then you could tailor your policies, your procedures, and your controls. What are some baselines? And I apologize if I'm stating the obvious, but you'll be surprised how often I'm engaged to assist a firm, assist an institution, and when we start doing our internal investigation, we realize that, the firm wasn't screening international wires, or there was a failure in screening international wires, international items. One thing we're going to talk about as a common mistake is screening every field in an incoming or outgoing funds transfer. I can't tell you how many cases I have handled and I am handling where the firm's systems wasn't screening all fields. Remember, you're responsible not only for the parties, you're responsible for addresses, reference lines, etc., and we'll talk about that. Screening new accounts. We've had situations where an institution will open a new account for a customer, onboard them, but fail to do an OFAC screening until days later, weeks later, etc., and lo and behold, this person, this entity is on the list. You need to have controls in place where you do that screening. A lot of the firms I work with, they do it during nightly processing. That's fine. OFAC will say, hey, that's your risk-based approach, but make sure you have controls in place that you're not allowing that customer in that gap to be processing any activity. Because should that customer who just opened up an account during nightly screening appear on the list and they did, some sort of transaction during that day, it's a violation of law. Now, you need to screen all your existing accounts regularly. Just because you screen them at account opening doesn't mean that your job is done. You could bring on a person that is, no problem, no issue, but lo and behold, a year later, a decade later, they fall on the OFAC list. So you need to regularly screen your accounts. Again, the FFIEC manual, OFAC leaves it up to the institution as to determine the frequency. I think with today's software that most everybody has, this screening occurs usually during nightly processing, that your customer base is screened every night. You need to do it regularly. At a bare minimum, you need to do it every time OFAC updates the list. But I think to be safe, you should probably be doing it nightly. You need to understand your online banking operations. What can your customers do online without any type of interaction with the bank, the firm, the institution? Can they open up accounts? Can they process funds transfers? Can they just check balances? Again, you want to be able to understand how much they can do, because the more they can do, the more OFAC controls you need to make sure that apply to those types of activities. Loans prior to funding, it should be just loans, period. As we've seen in the BSA AML space, there has been a lot more focus on examiners asking you, tell me about your credit underwriting. Okay, good. Well, tell me also about your compliance due diligence that you did with respect to this loan. Show me how you scrubbed the borrowers against the OFAC list. Show me how you scrubbed the guarantors, co-borrowers, etc. Make sure that you apply these controls to your loans. Something that I've seen, especially over the past year, is where now we are beefing up the firm's contracts, the firm's terms and conditions, the bank's credit agreements, syndicated loan agreements, where we make sure that we have clauses that are reps, warranties, and covenants, where the borrower, the customer, is telling the institution that I agree not to use these proceeds in any, sanctionable activity. The source of funds that I'm going to use to repay this loan, if it's a loan, are going to come from non-sanctionable activity, use of proceeds, again, source of funds. Sometimes you even have reps and warranties and covenants that talk about, the ownership. I have here at the firm, partners and colleagues that do a lot of, M&A work, a lot of, transactions, loan transactions, syndicated loan, and more they've been getting me involved to make sure that these documents have, the reps and warranties that will assist the bank should there be a problem in the future, assist the firm. Should there be a problem in the future, we could point to this and say, hey, look, we put the customer on notice. The customer, the borrower, again, agreed. They repped. They gave us a covenant that none of this was going to occur. So I think this is a good time at your firm to kind of take a look at your documents and see if you have those provisions in there that cover this area. Reroute apparent matches for due diligence. As you know, there's a big difference between an OFAC alert and a positive match. I've seen the examiners that they want to see that your policies and procedures spell out, how this is going to be determined. Who's going to be responsible for, signing off on this being a false match? Do you have some sort of dual control? And remember, folks, we also have our SAR filing obligation. If you have a positive OFAC match, you're not necessarily out of the woods. You need to do an investigation to determine, is there something that you should be filing a SAR on? Remember that you do not need to file a SAR if you're solely going to report the designation. But if there is activity that is suspicious, if there's something that you look at and now you want to file a SAR on, you have that obligation. And then testing and training goes along hand in hand with our AML regime. You have your policies, you have your procedures, you have your systems where you got to test it. You got to make sure it's doing what you're doing, and training. You can never get enough training. What you're doing here today, again, you're assisting your firm, your institution comply with its training obligation. All right, let's jump to some common mistakes and some lessons learned. Some of these I've mentioned already, so I'll kind of move quickly so we can make sure that we cover the entire presentation. Relying on an outdated SDN list, that's basically the issue I talked to you about, that your system is not updating the list. OFAC constantly is updating this list that has hundreds of thousands of persons and entities. It's it's adding people, it's removing people. You can't use it as an excuse that, oh, it was the system's fault. Remember, you can delegate the function, but you cannot delegate the responsibility. So I always tell my clients, make sure you have a fallback manual, check and balance where you can sign up on OFAC's website to get an email alert every time OFAC updates its list. I get those emails, I sign up for it. What you do is you pick a name from the email list you just got, and the following day you run it through your system, and you make sure that your system captures it. I think that's an easy manual check and balance to kind of keep tabs on your system. Next mistake, I've seen that some people just focus on the list and they don't worry about the country sanctions program. Remember, both are part of your OFAC compliance. And I get this question all the time, can I rely on another financial institution to do the OFAC scrubbing or on a service provider? The answer is absolutely not. I get the question all the time, Andy, I'm looking at this transaction. It might be subject to OFAC, but I received it from another U.S. institution. Aren't I safe? Answer is no. We are responsible for our own house, and if that other institution dropped the ball, that's their problem. We cannot, delegate the responsibility of OFAC compliance to anyone. Some of the other common mistakes, again, are pretty basic, but they're worth repeating. You need to have policies and procedures, written policies and procedures that cover this area. The examiners, the regulators want to see the who, the what, the where, the how, the when of how you're complying with OFAC. It is stressed throughout the entire FFI, EC, BSA, AML examination manual. They say that an institution's compliance program, written compliance program, again, is the cornerstone of the institution's efforts in this area. Common mistakes, I'm going to talk about it. One I'm going to focus on is the funds transfers and also trade finance. I'm going to clump them together because the notion is the same, that you're not just responsible for the parties. you're not just responsible for the names. You're responsible for, in the funds transfer field, for all fields, addresses. Because sometimes you may have a funds transfer that the names don't hit any list, but the address of the originator is Iran, or the address of the beneficiary is Crimea. And again, if your system is not scrubbing all fields, you're basically gonna, you're increasing the risk of a violation in this area. And I'm gonna talk about the reference lines next as the lessons learned. Same with trade finance. You're not only responsible for the parties, but you're also responsible for the documents and the underlying transaction. You can have a trade finance transaction where the parties are fine, but the underlying purpose of the transaction is sanctionable activity. Let's say the underlying purpose is commercial activity with Syria, commercial activity with Iran. So you're responsible for everything that is presented in those documents. All right, what are some of the lessons learned? Again, unfortunately, I've had opportunity to work with many firms in this area where there has been an OFAC issue, and these are kind of some of the recurring themes that I have seen when we have had to go to OFAC. Hopefully, we're going to OFAC with a voluntary self-disclosure. I'm going to talk about that, next with what OFAC will look at when you're facing a possible violation. And these are the ones that have played out the most. First, I've mentioned the reference lines. It's happened so many times where an institution feels that it is scrubbing its funds transfers correctly. It says, Andy, I'm scrubbing the parties. Andy, I'm scrubbing the addresses. I'm in compliance, right? Well, oftentimes they forget those reference lines. And many times the originator, especially on incoming funds transfers, can put a nice little message on that reference line where that reference line can tip you off to it being a sanctionable transaction. We've had cases where in the reference line there has been references to Cuba. There have been references to Iran. There have been references to people and persons that are on the SDN list. So you need to make sure that your system is not only checking names, not only checking addresses, but also scrubbing the reference lines. That flows into the second one, system-oriented issues. I talked about already, the failure to timely update, and I gave you a practice point on what you could be doing that's kind of like a manual check and balance. But I'm sure you've all heard that now the examiners are asking, well, tell me about your system's, search sensitivity and your fuzzy logic, things that I have never thought about before. I thought that was perhaps a Sesame Street character. They're asking you to describe what is your search algorithm. And again, the bad guys know that they're on the list. The bad guys purposely misspell their names or misspell references to their names. When there is an F in the name, they put PH. Where there's a Z, they put an S. So now the expectation is that your system is going to have the sensitivity to pick up those name derivations. As a matter of fact, I'm actually looking at the first day letter from one of the federal functional regulators that a client of mine received, and one of the questions is the following. It says, describe the processes used to achieve compliance with OFAC requirements. Include the metrics, any fuzzy logic, and algorithms used by each automated system. So folks, we're seeing now that the examiners are not only wanting to see that your system is searching for exact matches, but even name derivations you're responsible for. So more lessons learned. AML due diligence, as I mentioned a few moments ago, we're becoming a lot more sophisticated. We take AML investigations to great lengths. I had the other day the head of compliance department tell me, Andy, at our firm, we don't have analysts, we don't have investigators. I have a bunch of bloodhounds. They don't stop until they find a body. And folks, as a result, we're discovering a lot more, detecting a lot more, and oftentimes we detect it after the fact. I've had multiple cases where a bank, a firm, an institution is investigating a transaction for AML purposes. It triggered some sort of flag, some high-risk country flag, some round dollar volume, amount flag, etc. Who knows what? They start asking questions. They start getting supporting documentations. Lo and behold, it was activity subject to OFAC sanctions. So how can we mitigate that? You got to have strong CDD. It all starts with knowing your customer and knowing your customer's business. I think we've gotten to the day and age that if you are onboarding a customer and that customer presents a higher OFAC risk because of the business that they're in, I identify one here in the materials exporters and travel agencies, for instance. You need to be asking, OFAC questions at onboarding and in your periodic refresh. Do you do business in this areas? Because it may be perfectly legal for you to have as a customer a Chilean exporter, a Mexican exporter, and they could do business in Iran, in Cuba, but they can't process that activity through your account in the United States. But the only way you can know that is if you ask the questions. So you need to start incorporating OFAC compliance type questions in your onboarding. Be mindful of your exporters and your travel agencies. Those, I'm not trying to segregate them, but in my experience, I've seen those as the ones that raise a lot of time heartburn when it comes to OFAC compliance. And we've had a few cases, one just recently, where a current topology, a current pattern that was related to unlicensed Iranian activity. As we know, the sanctions against Iran have worked. They've been very strong, very tough, and we've identified activity that are coming to or from individuals in Turkey or trading companies in Dubai. And when you investigate, when you peel the onion back, they're actually front companies or front persons for Iranian activity, unlicensed Iranian activity. So be mindful of that as you move forward in your compliance area. All right. The two sections I have left is, again, what are the enforcement guidelines in Cuba? And I want to try and wrap up in about 15 minutes so we have time for some Q&A if there is. What are we trying to avoid? Obviously, at the end of the day, we don't want to come out in that list that I showed you earlier. We don't want to be a firm or institution that gets hit with sanctions. We want to avoid penalties. And before diving into it, let me dispel a myth that voluntary self-disclosures are bad. Wrong. Or you're only allowed to do one voluntary self-disclosure. Wrong. Again, oftentimes this could be your best friend, a voluntary self-disclosure, and it could often be your biggest mitigant. So I'll say it now and I'll repeat it. When in doubt, make sure you are voluntarily self-disclosing a transaction, a series of transactions, an activity that you think across your institution subject to OPAC sanctions and you may have missed it. Now, in September 2008, and then in November 2009, they issued as a final rule, what are the factors that OFAC is going to consider when they are determining whether to hit your firm, hit your institution with a civil money penalty? And some of the general factors that they're going to consider is, first, was the conduct of the institution willful or reckless? Or was it unintentional? Was it inadvertent? Was it human error? In the slide that I had early on, that was, some of the big fines where it was multi-million-dollar fines, the conduct that was alleged to have occurred was, egregious, where it was, employees of the institution stripping information from funds transfers so the U.S. correspondent, the U.S. affiliate wouldn't be able to detect that they were subject to OFAC sanctions. Again, OFAC determined that that's willful conduct, reckless conduct. I've had other cases where we've gone to OFAC and it was unintentional. It was human error. It was inadvertent. Again, OFAC is going to consider that. Again, OFAC is reasonable. They're very reasonable when they're when they're looking at potential violations. Was there awareness of the conduct? Did you know that this activity was subject to OFAC and you just hit send? Or was it impossible for you to know because nothing on the face of the transaction tipped you off to an OFAC sanction and you only found out about it after the fact because of some sort of investigation that you did? Harm to the sanctions program. In other words, could this have been subject to a license? OFAC from time to time issues licenses to individuals and entities to do business that would otherwise be considered sanctionable. Is this activity that you miss, could it have been subject to a sanction? They'll consider that. They're going to consider the existence and nature of your compliance program. So that ties back to what I told you before. Make sure that your policies, your procedures, your systems, they address OFAC. They address your controls. They address the who, the what, the where, the when, the how. OFAC will consider that. Let's say you did have a transaction that you missed, and it was because there was some sort of gap or some sort of deficiency in your compliance program. Well, what remedial responses have you taken to close that gap, to mitigate the likelihood of reoccurrence? Did you expand your internal denial list? Did you conduct more training? Did you enhance your policies and procedures? If it was human error, did that employee get disciplined? Did that employee have to do more training? Did you send letters to your customers? We do that all the time, and I'll touch upon that in the next slide, in the next couple slides about educating customers. OFAC will also consider, again, as I said, it being cooperation. Did you self-report this? That is the single biggest mitigating factor that OFAC will consider. OFAC, I think, has said publicly that they at least, if they're dealing with a voluntary self-disclosure situation, that is that you, the firm, you, the bank, you, the institution, are coming to OFAC to voluntarily tell them that this activity you missed, this transaction you processed, this customer you failed to detect. If you're going to them, they at least chop whatever type of penalty they were even considering at least in half at that point. So again, it's the single biggest factor that they consider. So OFAC, again, carefully examines, each of these factors when they're determining, a potential penalty. All right, turning to some of the takeaways before we go to Cuba. And I know I'm close to 15 minutes, so I may have to kind of run through some of the stuff a little bit more quickly, so I apologize. What are some of your takeaways? Well, first of all, consult your lawyers if you have an issue in this. I know that might sound self-serving, but again, this area is strict liability, and it could get you in trouble quickly. When in doubt, self-disclose. As I said, it will reduce your potential penalty under the regulation. It shows that you're being cooperative. It shows that you're being proactive. It shows that you have a culture of compliance. If you do identify either transaction, activity, or something that you miss, you need to do an internal investigation. You need to be able to tell OFAC, this is what happened, this is why it happened, and we've gotten to the bottom of the barrel. There's nothing else you, OFAC, need to be concerned with. Cooperation, again, your remedial action. What did you do to prevent this from happening again? What you're doing here today, training. You got this information, again, disseminated. Talk to your employees, talk to your staff, talk to your affiliates. Oftentimes, some of the firms I work with, the bad act happened, unintentionally, but it was caused by an affiliate, an offshore affiliate, head office in another country, a foreign branch, etc. Make sure you disseminate this to your customers and to your affiliates, better said. Strong CDD and contractual provisions. I talked about that already. And then educate your customers. There is nothing wrong. There is nothing illegal with you educating your customers in this area. There's many institutions I work with that identify either customers or a segment of their customer base that raise the level of OFAC risk. What we've done is we've sent those customers letters, and we remind them, hey, your account here in the United States is subject to OFAC sanctions. And you cannot process any activity directly or indirectly through this account that is subject to the sanctions. Again, that's good to educate them, and also it's good if you were to have a problem with OFAC, we can show it as a mitigant saying, hey, you know, we tried to educate our customers. All right, with the time I have left, I'm going to try and run through Cuba very quickly to leave some time for questions. I'm not sure if there are questions or how many questions, but I see that we have just under 15 minutes, so I'll try and do Cuba quickly. Cuba before was easy. As a practitioner in this area, Cuba before was the simplest because whenever I would get a call about a Cuba question, the answer was simple. It was no, you can't do it. Cuba traditionally was the broadest sanctions program around. I would tell clients that if they're calling me and if they were even asking about Cuba, I said, likely you had already probably violated the law in some way. That has now changed. There has been some tweaking and some easing of the sanctions. And now as an institution, we need to be aware of it. I'm going to, again, skip ahead because time constraints. What has happened, as I mentioned, the embargo, the sanctions have been around for decades. But we can all agree that these amendments, this relaxation that has taken place over the past 18 months have been the most significant. It started in December 2014 when the White House announced this new position, and now there have been 4 sets of regulations that have been promulgated, 2 in 2015 and 2 in 2016, implementing these changes. The biggest sectors that are affected, or the major sectors that are affected, are financial services, travel, export, and telecommunications. The important concept before leaving the slide is the last one. Folks, the embargo is still in place. What we're talking about here today are certain tweaks, certain relaxation, but the overall embargo and sanctions against Cuba are still in place, and OPAC is still sanctioning companies, entities, financial institutions for doing prohibited business with Cuba. I think this year there have been at least 2 that I can remember off the top of my head, 2 civil money penalties that OFAC has issued against entities and institutions for violating the OFAC sanctions. All right, at a high level, what does it mean for financial services? Well, now U.S. depository institutions can open up an account at a Cuban financial institution to facilitate authorized transactions. That is the important part. It's not for any and every transaction. It's just for authorized transactions. Those authorized transactions now are just 2 buckets. Travel related is one. To facilitate U.S. travelers while on the island, they can now avail themselves of this account of a U.S. bank in Cuba. It's important to know, I'm not talking about a brick and mortar U.S. branch. No, it's the account of a U.S. bank at a Cuban financial institution. And then also that account could process permitted exports. As you're going to hear in just a couple minutes, U.S. companies, U.S. persons can now export certain products to Cuba, mostly to the private sector. Now this account of a U.S. bank in Cuba could be used to facilitate payment, settle transactions. The authorization doesn't work in reverse. It doesn't permit the Cuban financial institution to open up an account at the U.S. financial institution. If we had more time, I'd explain to you why. Again, that's not likely right now anyways because of all the judgments against the Cuban government that exist here in the United States. The plaintiff's attorneys and the plaintiff's bar have said the moment that an account of a Cuban financial institution is open here, it will immediately be seized and garnished to try and pay the judgments. What else can a financial institution do if they choose to? It's not automatic. They could process credit and debit card transactions by any person authorized to engage in financial transactions in Cuba. So what do you need? You need an authorized person in Cuba. The transaction must be authorized and for a permitted purpose. What many of the institutions have told me is like, Andy, well, what kind of due diligence do I need to do to ensure that? Well, Treasury put somewhat of a limited safe harbor where it says persons subject to U.S. jurisdiction, which is the financial institution, may rely on the traveler with regard to compliance with this authorization, provided that such person, which is the U.S. financial institution, does not know or have reason to know that a transaction is not authorized. The concern that has been told to me is, what does that last part mean? More importantly, how is my examiner going to interpret that? How is my auditor going to interpret that? And are they going to impose additional due diligence requirements? Right now, there's one institution that has elected to permit debit card and credit card processing or transactions on the island, and that is Stonegate Bank out of Florida. Otherwise, there's no other institutions. Travel, this is the biggest change. I think it's important for you to understand, because you as a financial institution, you may find yourself processing these types of transactions on behalf of your customers. We need to understand that travel for tourism and tourist activities continues to be prohibited. What is permitted are 12 buckets of authorized travel that we are going to see in a second. Again, if I had more time, I would talk about carrier services. Now there is a general license authorizing commercial air carrier service and commercial vessel carrier service to Cuba. That's why we're seeing now the cruise lines going to Cuba, and at the end of the summer, we're going to start seeing the commercial airlines going. Travel agencies. Before, travel agencies, U.S. travel agencies, needed a specific license from OFAC to be able to arrange for travel to Cuba. Now that is no longer needed. So you could bank a U.S. travel agency, and they could be arranging for authorized travel to Cuba, and there's no need for a specific license. Just try to move quickly. When these changes first came about, the banks that found themselves processing and the financial institutions that found themselves processing these types of activities were refusing to process because they were worried about what underlying due diligence they needed to do on the transaction. Was the traveler actually going to Cuba for one of the permitted purposes? What did they need to do? Well, OFAC issued a frequently asked question that was worded asking whether a financial institution is required to independently verify that an individual's travel is authorized when processing such a transaction. Thankfully, the response we got was no. Financial institutions do not need to independently verify. We could rely on the traveler. These are the 12 buckets. Though the one that's most commonly used is visiting family, professional research, and people-to-people. Let me just jump ahead. All right, exports, I mentioned to it. Why is it important to talk about it in just a couple minutes? Because you may find yourself processing this type of activity for your customer that may engage in exports to Cuba. They expanded the category of certain exports without a license. The categories now permit U.S. persons, U.S. exporters, to sell building materials, equipment, tools for use by the private sector in Cuba, tools and equipment for private sector agricultural activity, tools, equipment, supplies, instruments for use by the private sector entrepreneurs, and telecommunications. Again, but for telecommunications, the first three categories are linked to the private sector. Important to touch real briefly, this exception only applies to U.S. persons, U.S. exporters. If you bank a Chilean, to use the same, not to pick on a Chilean or Mexican exporter that is selling these same products to the private sector in Cuba that is permitted, that activity still cannot be processed through the United States. These exceptions are limited to U.S. persons, U.S. exporters. The last thing I'm going to touch upon, because again we're running out of time, and I at least want to leave a few minutes for questions, is financing. This was a big challenge that was removed in January. Before, a financing to Cuba, to a Cuban entity, to a Cuban national was completely prohibited. Anything that you were authorized to sell to Cuba needed to be paid for in full in advance. It was tweaked a little bit in January 2015, where it said, well, it needs to be paid for before it exchanges hands, which at the end of the day really didn't do anything. Now, this was a big challenge removed, where now U.S. exporters can provide financing to the private sector that they are selling to. They could sell items on an open invoice, which they were never able to do, and now banks, depository institutions, can now finance authorized exports and re-exports, so long as it's not agricultural items. So that was a big challenge that had always been communicated to me that was occurring. And finally, on remittances, before there were thresholds, limits, now it's unlimited remittances you could send to any Cuban national. But I want to highlight that there are still challenges on doing business in Cuba, whether you're a financial institution or whether you're an entity. There's challenges on the technology side, on the depth and breadth of internet capabilities, telecommunications, etc. There's importing issues. How can this private sector import merchandise? They're having a challenge there. And identifying the private sector. Again, these are all challenges that we've identified, but as an institution, it's important for you to understand where these changes are, because you may be finding yourself processing activity for your customers. I've only left, I think, 3 minutes for questions. I apologize, but I don't know if, Lauren, if there's anything there, because I think as far as the slides go, I've been able to run through what I wanted to get through.
Well, thank you, Andy. That was incredibly insightful and really interesting to hear all of that information. You did manage to answer quite a few of the questions that came in throughout the presentation. So since we have time maybe for one, what I'll do is condense sort of the recurring questions into one. And if you could answer that in the minute that we have left, that'd be great. So there's folks that are sort of wondering the extent to which this applies to their particular institution. So we have some folks, it seems that they're in banking or financial institutions that are U.S. based, and so their questions are, if I'm part of a regional bank, for instance, that doesn't have presence outside of the U.S., to what extent do we need to screen domestic transactions, and is it safe practice to maybe whitelist all U.S. persons or U.S. entities? And then on the other hand, we also have some folks that are from foreign institutions asking, if we find, for instance, an OFAC match, do we need to report this to U.S. regulators? So can you kind of speak to folks that are maybe foreign or U.S. based and how much they need to?
Perfect. I'll start with the foreign one because I'm actually dealing with that right now. If you're a foreign entity, a foreign bank, let's say, and you discover a positive OFAC match, there is no affirmative obligation for you to report that to OFAC. What you need to do is ensure, to the extent you can, that if that is a customer of yours or that is a counterparty of your customer, that you as an institution are not the institution that is processing that activity to or through the United States, because then you could find yourself with a problem. I'm working with an institution right now that unintentionally processed activity through its U.S. correspondent, and that activity was subject to OFAC. The U.S. correspondent blocked and reported the transaction to OFAC. We are now, again, because this institution is very serious, doesn't want problems with OFAC, we're doing a voluntary self-disclosure on behalf of a foreign bank to OFAC because they want to go to OFAC completely transparent, explain to OFAC that this was unintentional, that they do apply OFAC sanctions, because the last thing they want to do as a foreign entity is get on OFAC's list. So to answer that question, you don't need to affirmatively report it, but if you see that you find yourself that you have processed some sort of activity through the United States that was blocked, then you should likely come forward to OFAC to mitigate any type of chance that you're going to get on OFAC's screen, where OFAC's going to now start looking at you as a foreign institution that is facilitating this type of sanctionable activity. On the domestic side, I'm always very, very hesitant to whitelist anybody. I know the OFAC issued guidance last year where they talk about, safe lists. We recognize that we use, safe lists, but they're more often than not used when this particular customer keeps hitting as a potential match, but they're not. I think your OFAC risk is much smaller when you're dealing domestic, but I would just caution you on just doing blanket non-screenings, because you may have a customer that all of a sudden may start processing some sort of foreign activity, and lo and behold, that is something sanctionable. So I would just caution you with that. You may not have to do the frequency of the screening as much, but just to flat out refuse to screen, I would caution that.
Excellent, thank you. Really great advice there. So we are down to the wire, so unfortunately we don't have time for any more questions, but we will collect these and try to get some answered via email. If you do want to contact Andy after this webinar, his information is up on the screen right now, and also I believe it was part of the handouts that are available for download. They're on the handout section of your screen. Also, we have recorded this webinar, so it will be available on globalradar.com for future reference and listening. And also, if after learning about all of these regulations and you're interested in learning more about a software solution to help you comply with this, please feel free to learn more at globalradar.com. To learn more about the solution, you can request a demo of the solution, and you can even see upcoming webinars also that we're offering. Lastly, if you have not done so already, I encourage you to sign up for the BSA News Now newsletter to receive free once daily news briefings on developments and critical industry changes related to topics such as this and AML, as well as to hear about upcoming webinars in the future. So you can do that at bsanewsnow.com. So Andy, thank you again for your time. This was a really wonderful presentation, really enjoyable, so thank you, and thank you to the audience for your participation today. So that concludes today's webinar. So everyone enjoy the rest of your day.